Good afternoon, everyone, and welcome to our OSHA Record-Keeping webinar. My name is Donna Ennis, and I am the Director of Diversity Engagement and Program Development for Georgia Tech's Enterprise Innovation Institute. And we are happy to bring to you today some training about keeping records under the OSHA guidelines. Before we get started, I need to be able to move the slides a little bit so that we can introduce our speakers. Lauren, can you move the slide, please? Thank you. Wanted to just show you the agenda. We'll have some welcome words from Carmelita Scott, who is the president and CEO of the Atlanta Airport Chamber of Commerce. And then we'll have our presentation from our team from the Safety, Health, and Environmental Services Group at Georgia Tech. While we get started, let's have some words from Carmelita Scott.
Well, good afternoon. Thank you for having me this afternoon. The ATL Airport Chamber is an organization that covers the airport region and the Southern Crescent, and our main function is to help small businesses develop. And we do that in a variety of ways. So you can check our website to see more, but that is your little hint for the day. Thank you.
And thank you, Carmelita, for being a co-host and a partner of the Atlanta MBDA Business and Advanced Manufacturing Centers. I'd like to start by just thanking our corporate sponsors, Comcast, EPCO, and Train Technologies, who continue to provide the support, both financial and otherwise, to our programs. So the MBDA Centers at Georgia Tech, our main mission is to grow and strengthen minority business enterprises. We do that in a variety of ways with the ultimate goal of having a positive impact on our communities and to help our companies generate revenue, create and retain jobs, thereby having a positive effect. We're part of a national network of 40+ centers and projects that are partially funded or funded by the Department of Commerce Minority Business Development Agency. The MBDA has been around since the late 50s and is the only federal agency that was established to focus on growing and strengthening minority-owned businesses. Here's our team. We have a great team of folks, from finance people who can help you source capital to business advisors, manufacturing advisors, as well as program specialists and managers, all working together to bring you programming like today. So about a year ago, with the onset of COVID-19, we received some special funding from the CARES Act to provide training and technical assistance to companies who are obviously negatively affected by the pandemic. We've done everything in the past year, from providing webinars such as this on health and safety, to training on employee engagement, to technical assistance around helping our companies secure payment protection program or PPP funding, or emergency injury and disaster loan funding as well. So we've been working really hard over the last year to bring you technical assistance, funding, and education and training to help you stay, thrive, and survive during the pandemic. This is our last webinar, and I want to thank our Safety, Health, and Environmental Services Group who's hung in there with us for the past year, bringing you these webinars about health and safety. We really want to thank all of you as well for joining us during this time over the last year, and hopefully we've been of some service to you in terms of helping you keep your business alive during these trying times. So with that, I am going to turn this over to Paul Schlumpler with the Safety, Health, and Environmental Services Group at Georgia Tech to talk about OSHA record keeping. Paul.
Thank you, Donna. I do want to thank Donna and the good folks, the MBDA Business Centers, and Carmelita as well, for sponsoring this event. And I thank all of you for joining us today. My name is Paul Schlumper. I'm the director of the Safety, Health, Environmental Services Group at Georgia Tech. Very happy to be here with you to talk about one of my favorite topics, OSHA record keeping, OSHA reporting. it is a topic that a lot of people struggle with sometimes, and sometimes the decisions can be difficult. So it's always interesting to get into this topic and deal with the challenges that can sometimes come up. I did want to mention before we jump into record keeping that we do offer in our group quite a few services related to OSHA, the OSHA on-site safety and health consultation program. We offer a variety of courses, one of which is OSHA record keeping. You're going to get a taste of it today for about an hour or so, but we offer a 4-hour course on this if you want to dive in a little bit deeper. And we offer a variety of courses in a variety of different safety, health, environmental topics. So Brandon, if you don't mind throwing our main website into the chat for folks. If you need help with anything safety, health, environmentally related, please keep us in mind. Go to our website and contact us. We are there to try to help you. The consultation program in particular is one where we work with small to medium businesses in Georgia. If you have 250 employees or less at your site, 500 employees or less total U.S. corporate, we can come out and work with you and do an on-site safety and on-site health or both site visit and just try to help you identify potential hazards and OSHA compliance issues. The program is no cost and it's confidential. You do need to agree to correct any serious hazards that we identify as part of that service. So just wanted to mention that and some of the other services that are available to you. So let's go ahead and jump into OSHA record keeping. It's, I used to have a sign in my kitchen that read, trying to raise teenagers is like trying to nail Jello to a tree. It was always one of my favorite signs because I've raised 3 teenagers myself. Me and my wife have. But I almost would say the same thing about record keeping. Making those OSHA record keeping decisions sometimes is like trying to nail Jello to a tree. It can be very difficult. And, a lot of times the challenges are tough. But I want to throw a couple of things out as we get started, just as premises to OSHA record keeping. First and foremost, just a reminder, if you've never dealt with record keeping, that OSHA record keeping and workers' compensation are 2 completely separate systems. We get that a lot in our questions. People, a lot of times people that do OSHA record keeping for an organization also do workers' comp. And so they want to naturally put the 2 together and draw comparisons. But honestly, they are 2 separate systems. Just because something is recordable doesn't mean it's compensable and vice versa. So forget about workers' comp for the next hour. A couple of other things about OSHA record keeping. It really doesn't have any bearing as far as who is at fault that resulted in the injury and or the illness. So a lot of, the employee could have been doing something wrong or maybe involved in horseplay or, not following company policy. Those might be relevant in workers' comp, but they're not relevant in OSHA record keeping. You really just need to look at what were they doing, where were they at the time of the injury or the illness, was it in the interest of their employer, and was it severe enough to be OSHA recordable? There are a couple of others that I get into also. Try to forget about company cars for a while. That's usually not an issue for OSHA record keeping purposes. Might be for workers' comp, but not for OSHA record keeping. And try to forget about whether the employee is clocked in or clocked out. Again, we want to look at where were they, the employee, when they got hurt, and were they there in the interest of their employer. So those are a few things. We'll get into some more as we dive into record keeping, but I'm going to go ahead and start talking about these slides. So you see my contact there. I also give you the contact of Paige Rohrig. Unfortunately, Paige couldn't be here with us this afternoon, but Paige manages the safety branch, and she can also be another resource to you when it comes to OSHA record keeping decisions. And of course, Kenny Davis also works in the safety branch, and with us today is Brandon Philpott. Brandon works in the occupational health group, and any of our folks can help you with record keeping questions. So a few places, and I think we've already put a couple of these up in the chat, but some good references for you. OSHA.gov, record keeping. There's a whole page of record keeping information on the OSHA website. You see our web address, oshainfo.govtech.edu. And then you also see the professional education website from Georgia Tech, specifically for the OSHA record keeping seminar. So I hope you'll look into any of these additional resources. So let's start right off the bat with a question that I'm sure some of you have, and that's, how do I deal with COVID-19 recordability? Well, like the rest of recordability, COVID-19 decisions can be really difficult. But here are the three main elements that you've got to look at in making those decisions about recordability for COVID-19. By the way, if you want to read more detail about this, there's a memo dated May 19th of 2020 that you can get to from the OSHA website, from the COVID-19 resource page of the OSHA website, that goes into quite a bit of detail about COVID-19 recordability and reportability. So first and foremost, you have to have a confirmed case of COVID-19 as defined by CDC. So you have to have a positive test for it to be a recordable COVID-19 case. An employee comes to you with symptoms and they're not feeling well, you know, it isn't possibly recordable until you get a positive test. Now, the second bullet is going to be the most difficult part of the decision for y'all. The case has to be work-related as defined by the OSHA record-keeping regulations in 1904. That can be a very difficult decision, especially with COVID-19. But that's the ground rules that they're laying for us. And then the third criteria is the case has to involve one or more of the general recording criteria set forth in the 1904 regulation. Those general recording criteria might be medical treatment is required. It might be they lose consciousness. It might be they have to have days away from work, or maybe days of restricted work. Maybe they can't come in and work a full day. These are all examples of general recording criteria, and we'll go through those in this presentation. But I want to talk just a little bit more about that second bullet, the work relationship bullet, because that is going to be the hardest part of your decision. If you read the May 19th memo, and thank you, Kenny, for, Brandon, for putting that up. What OSHA is going to look for is the reasonableness of the employer's investigation into work relationship. So they're going to basically ask questions. If they come in and inspect you and they have a reason to doubt your decision about COVID-19 recordability, they're going to look at how well you investigated. So let me give you a couple of instances without getting into too much detail, but I think this is something that you're probably interested in. A couple of examples. COVID-19 illnesses are likely work-related when several cases develop among workers who work closely together and there's no alternative explanation. That's one case. An employer's COVID-19 illness is likely work-related if it is contracted shortly after lengthy, close exposure to a particular customer or coworker who has a confirmed case of COVID-19 and there is no alternative explanation. Case number 3. COVID-19 illness is likely work-related if the person's job duties include frequent close exposure to the general public in a locality with ongoing community transmission and there's no alternative explanation. Number 4, COVID-19 illness is likely not work-related if that person is the only worker to contract COVID-19 in their vicinity and their job duties do not include frequent contact with the general public. Fifth one, an employee's COVID-19 illness is likely not work-related if outside the workplace that person has had close and frequent association with someone like a family member, significant other, friend who has COVID-19, is not a coworker, and exposes the employee during the period in time which they were likely infectious. So I know those are just a few examples, but I would refer you to that memo, the May 19th, 2020 memo for your COVID-19 recordability questions. Again, the work relationship is going to be the hardest part about that because that's going to be the part that you really have to to look into and make a decision, make a determination. So that's COVID-19. I'm going to move on to just general OSHA recordability now. There are some newer requirements. They're not that new anymore. It's been a few years, but some of you may be required to electronically file or report your injury and illness information every year now. So establishments with 250 or more employees, if you're required to keep the records, and establishments with 20 to 249 employees that are in certain industries will have to go to the OSHA website and actually electronically submit their summary information every year. That's usually around the beginning of March when those submissions are actually required. So that's a fairly new requirement for some of you. So again, in 2020, the requirements, the timing requirement was by March 2nd. And you can expect that date to pretty much stay the same from year to year from this point forward. So you're going to submit electronically your calendar year information for the previous year, and you're going to go to the OSHA website to do that. Now, there are a number of anti-retaliation protections that came along with these additional electronic submission requirements. Employers are definitely prohibited, discouraging workers from reporting an injury or illness. And workers have the right to report work-related injuries and illnesses, work-related hazards. They even have the right to report to OSHA, to issue a complaint to OSHA. So very, very important that employers understand these rights and respect them. So as far as general record keeping is concerned, not everybody has to keep these records, but a lot of employers do. There's the first exemption is size exemption. The company, if the company had 10 or fewer employees at all times during the calendar year, then they're not required to keep those records the next calendar year. Now, a couple of things. First of all, this is the entire company, right? So if you had 6 employees in one location and 6 employees in another location, you had 11 or more employees in your company, and so you can't claim the size exemption. So the size exemption is the entire corporation. You also have to look at who is your employee for the purpose of record keeping. Obviously, people on your payroll are your employees, but temporary employees that you bring on board from a staffing agency, they're considered your employees for record keeping if you provide their daily supervision. So if you have 7 employees on your payroll, but you bring on 4 temps, at least at one point during the year, then you're going to be required from a size standpoint to keep the records. So anybody you supervise on a daily basis, they're yours for record keeping purposes. Now, the other exemption is the industry exemption. Unlike the size exemption, the industry exemption is actually per establishment or location. So you might have 2 locations, like I said, both of them with 6 employees, but let's say one of those locations is a retail store. Then that particular location, the retail store, would not be required to keep the records because they fall under an industry exemption. There's an appendix to subpart B in the OSHA regulations that lists the industries that are exempt. If you're in agriculture, construction, manufacturing, transportation, you're not going to be exempt. You're going to be required records. But as you see in some retail and service sectors, there are some industries that are partially exempt. Now, why do we say partially exempt? Well, the reason we say partially exempt, excuse me, I thought we had a slide here. The reason we say partially exempt is you still might be required to meet some requirements if you're asked to do so, or you still might be required to report more severe injuries and illnesses to OSHA. So even though you're small, even though you meet the industry exemption, if OSHA contacts you and asks you to participate in a survey, or the Bureau of Labor Statistics contacts you and asks you to participate in the survey, you're going to be required to keep the records. So that's why they call it a partial exemption. And towards the end of this presentation, we'll talk about the severe injury and illness reporting requirements. Again, even if you meet either of these 2 exemptions, you still have to meet the reporting requirements if you have an employee suffer a severe injury. All right, so you've heard me mention the term establishment so far. Establishment is basically a single physical location where work is done. So these records that we have to keep, they're kept at the establishment level. Again, back to those two different locations with that small company. If one location is in Atlanta, the other location is in Dallas, Texas, that's two separate establishments. And so OSHA would require each of those establishments to have the records if they don't meet the exemptions. If the two locations are both in Atlanta and they're a block away from each other, then you would be fine linking those two together and just having one set of records for those two. So it really depends on the geographic distance between the two locations. If they're miles away, separate them out. If they're not miles away, they're blocks away from each other, then you can combine them into one log. Now, short-term establishments, you can combine all those into one log. What's short-term? In operation for less than a year. So this is especially relevant in the construction industry, where you have job sites that might exist for just a few months and then the job is done and you move on to the next site. Those folks don't have to have a separate log for each of those establishments. You can just keep one short-term establishment log and keep all of your sites that are in existence for less than a year on that log, and that is just fine. Of course, nowadays we have a lot of folks still working from home, right? You don't have to have a log for everybody's house. That's not required. But what you do have to do is link everybody to an establishment. So if you got people scattered out there working from home right now, make sure if they do get injured or ill and it's a work-related recordable event, that you link them to an establishment. And you can decide which establishment you link them to, the closest one that they are located to or where they normally report or whatever makes sense. But you do need to keep your logs at an establishment level. All right, so here are the basics of OSHA recordability. And actually not on this, not really highlighted on this slide, but the assumption is that the person actually does have an injury or an illness, right? So if you don't have an injury or an illness, you don't have anything to record. But in fact, if you do have an injury or an illness, for it to be recordable on the forms, it's got to be work-related, it's got to be a new case, and it's got to meet one or more of the criteria that we're going to go over. So let's talk first about work-relatedness. One of the people I work with at OSHA, who is very knowledgeable in OSHA record keeping and a really helpful resource to you, her name is Billy Kaiser. She is the assistant regional administrator for Region 4. But Billy always uses the term, she says, it's work-related till it's not. And I like that statement. What that means is if whatever happened in the workplace, then unless you meet some sort of an exception case, it's work-related. So if that person was in the work environment, if they were wherever they were as a result of or in the interest of the employer, then it's work-related until or unless you have an exception. So work-relatedness is presumed if the event or exposure happened in the work environment. That last bullet's important. The work event or exposure need only be one of the discernible causes. It need not be the sole or predominant cause. So what you've got to look at is, did the event or exposure in the work environment cause or contribute to the onset of symptoms? I know that doesn't sound fair to some people, but that is the criteria that OSHA uses in terms of trying to determine work relationships. So it doesn't have to be the major cause, it just has to be a discernible cause. So the work environment is really the establishment, the workplace. Might be the construction job site, it might be the manufacturing plant, but it can also be somewhere else that the person is in the interest of their employer. So it can be their pickup truck, it can be by the side of the road where they're working, it can be at a customer site, it can be at a lot of places. So here are some of those exceptions. Remember I said it's work related till it's not? I didn't invent that. Billy did. I'll give her credit for that. But these are the exceptions, okay? So these are the cases where it would not be work-related, and if it's not work-related, it's not recordable. So if they are present at the location as a member of the general public, you work for Target and the stores, and you're just there shopping today, you're not at work, and you slip and fall. That's not a work-related event. You were there as a member of the public. Symptoms arising in the work environment solely, pay close attention to that word solely due to non-work related events or exposures. So you do want to be careful. You know, you can claim this one, but make sure you've got good information to back it up. An example of this might be somebody is just sitting at their desk, not involved in any type of stressful activity, and unfortunately they suffer a heart attack. As long as you can show and demonstrate that nothing in the environment had any contribution to the onset of their symptoms, then you know that's where you would be able to apply this exception. Voluntary participation in a wellness program, medical program, fitness program, or recreational activity. Key word here is voluntary, right? If there's any coercion or any reason or pressure on that person to participate, that's different. But if it's truly voluntary and they're, you know, going playing basketball in the parking lot and they hurt themselves, then that's not work related. Eating, drinking, preparing food or drink for their personal consumption. That's not work related. Now, if you start getting into a situation where I'm making lunch for my team and I burn my hand getting the food out of the microwave, that's not going to be an exception. That's work related, but only personal consumption here. Personal tasks outside of assigned working hours. Now, you may remember that I said forget about clocking in and clocking out. This is the only exception where it's sort of relevant, all right? I go in I usually work 8 to 5, but I go into the shop at 7 o'clock to work on my kid's school project, and I cut my hand on a table saw. That's not work related. It was a personal task, and it was outside of my normal hours, so that's not a work related event. Now, I do the same thing at lunch. It's work related because lunch is considered part of your assigned working hours. So the hours are important for that particular exception. Personal grooming, self-medication for non-work related conditions, intentionally self-inflicted, all not work related. Now, this next one gets confused a lot. Motor vehicle accidents in the parking lot, the company parking lot or access road during the normal commute. Now, first of all, the company parking lot, if it is a company controlled parking lot, is part of the company's premises. That is part of the establishment. So everything else that happens in the company parking lot is work related, except something that involves a motor vehicle accident. Okay. So, and it has to be during the normal commute. So I trip and fall over the curb and hit my head in the parking lot. That's work related. It's got to involve a motor vehicle. And it's got to be during the normal commute. If I get struck by a car at lunchtime, that's going to be work related. Common cold or flu is another exception, not work related. And then the last one here, mental illness, unless the employee voluntarily provides a medical opinion from someone with the right appropriate qualifications that affirms that it is work related. Okay. So these are your exceptions. So basically, again, if it happens in the work environment, it's probably work related unless one of these exceptions holds. Now, work at home, again, a lot of us are working from home these days still. Work at home is only work related if it is involved in the actual work. It is not work related if it is involved with the general home environment. So you do have to look at the circumstances surrounding the injury or the illness. If I pick up a box of files, work files, and I wrench my back, that's work related. If the phone rings and I run to get the phone and I trip over the dog and fall and hit my head, that's not work related. That's the home environment. So you got to look at whether it's directly related to work or directly related to the home environment. All right, so we've set the stage here. We've talked about we've talked about work relationship. So what is recordable if it is work related? Well, this is your list of general recording criteria. So obviously a fatality is recordable. Days away from work are recordable. Days of restriction are recordable. Days of transfer are recordable. If medical treatment beyond first aid is deemed necessary or provided, that's recordable. If the person loses consciousness, or if you have another significant injury or illness diagnosed by a primary licensed healthcare practitioner, that's what all those letters mean. And it could be a doctor, it could be another healthcare person, then that would be recordable. So we're going to go through these quickly in detail. So days away cases, you do have to record if if the case involves one or more days away from work. Now, you do not include the day of the injury or the illness. So if the only day they miss is the day of the injury or illness, you don't have any days away from work. Might still be recordable if medical treatment is required or they lose consciousness, but you don't have a day away case. So you will check the box on the form for days away, and you'll start counting days. You count all days, not just work days. So you're going to count weekends, you're going to count holidays, you're going to count vacations. You were supposed to have a 2-week shutdown next week. You're going to count those days. And you're going to count them based on primarily either the medical opinion or whatever you deem necessary as the employer in the interest of that employee. So however many days away they needed, that's what you're going to count. And again, it doesn't necessarily have to be days they were supposed to work. You can cap your day count at 180, and that's 180 total days away and days restricted. So once you hit 180, you know it's a significant case. You can stop your count. You can also stop your day count if the employee leaves the company for a reason unrelated to the injury or the illness. Now, if they do have to leave the company, you typically would just put 1 day as days away if they would have had to have a day away or a day of restriction. But otherwise, you can stop your day count. Now, restricted cases there's something similar to days away and some things different. First of all, the day count's the same. You're going to count weekend days, holidays, shutdown days, vacation days. You're going to count all of those for restricted cases just as you would for days away. But what's restricted? Well, if they're unable to work a full workday, that's a restricted workday. If they're unable to perform one or more of their routine job functions, that's a restriction. So you see the example or the last bullet, an employee's routine job functions are those activities that they regularly perform at least once a week. So, the one mistake I do see people make sometimes is they automatically consider a case restricted as soon as the doctor writes a restriction. Well, you got to compare that doctor's restriction to their routine job functions before you decide it is a restricted case. So if the doctor says don't lift over 40 pounds for the next week, okay, and you go back and look at that employee's job and they never have to lift over 40 pounds, or maybe they do it once every 6 months, you don't have a restriction, not for record keeping purposes. So you do have to compare the doctor's restriction to the employee's normal routine job functions, things that they normally do at least once a week. Transfer is also recordable. So if they're assigned to another job, then you have to record those days. Again, either for part of the day or for the full day, you're going to count those just like you would days away or days of restriction. Now, the other major category of recordability is medical treatment. So medical treatment, you see the definition here on the slides. It does not include visits to that doctor or other medical practitioner just for observation or counseling. So any type of observation counseling or as you see the second bullet, diagnostic procedures, that's not medical treatment. So for example, an x-ray, that's not medical treatment. If a person goes to the doctor and they get an x-ray and the x-ray is negative, you don't have a recordable case yet. So any type of observation, counseling, or diagnostic procedure is not medical treatment. Medical treatment is management and care of a patient to combat the disease or the disorder. So keep that in mind. It doesn't matter where they go. It only matters what was done or what was deemed necessary. So I can go to the Mayo Clinic and they can put a Band-Aid on my finger and it can be first aid and I don't have a recordable case. I can also go to the nurse's station within our plant and maybe the nurse puts sutures on my finger and now I have medical treatment. So it doesn't matter where, it just matters what. Now, first aid is not medical treatment, and there's a first aid list here. These are, and this is meant to be an all-inclusive first aid list. So if something is deemed necessary that's not on this list, then it's medical treatment unless it's observation, counseling, or diagnostic. So non-prescription medication at non-prescription strength is first aid. Now, if the doctor says, you know what, I'm not going to write you a prescription, but just go to the pharmacy or, go to Kroger or the grocery store and buy some Advil and take 4 Advil. You've now got prescription strength of a non-prescription medication. That's going to be medical treatment. So even though it's over the counter, whatever the doctor recommends, that's going to dictate whether it's first aid or medical treatment. Tetanus in and of themselves, tetanus immunizations, those are not medical treatment. That's first aid. Now, there could be a more serious cut, and that might make it recordable. But the tetanus shot in and of itself is not recordable. Cleaning, flushing, soaking surface wounds, first aid. Wound coverings, including butterfly bandages and Steri-Strips, all first aid. Now, there is a distinction. Sutures are medical treatment, and surgical glue is medical treatment because surgical glue is typically applied to close the wound versus cover the wound. So there's a difference between surgical glue and liquid Band-Aid, for example. Liquid Band-Aid is considered a wound covering, and that would be first aid, but surgical glue would be medical treatment. Hot or cold therapy, non-rigid means of support, temporary immobilization devices used to transport accident victims, all considered first aid. Drilling of the fingernail or toenail, that's a fun one to talk about, right? Draining fluid from a blister, all first aid. Eye patches, removing foreign bodies from the eye using irrigation or a cotton swab. Now, if you've got to pull that thing out from the eye with tweezers or something else, that's different. That's going to be medical treatment. Now, removing splinters or other materials other than the eye, that's going to be first aid. Finger guards, massages, drinking fluids for relief of heat stress, all first aid. So if it's first aid, it's not recordable unless something else makes it recordable, like you lost consciousness or you had days away or days restricted, but otherwise it would not be recordable. All cases involving loss of consciousness have to be recorded if it's work-related. Now, there's no time frame here. A lot of people would ask, well, how long do they have to be out? If they lose consciousness, it's recordable, period. And then, there may be other cases. For example, you might, break a bone in your finger and not have any treatment administered, not have any prescription medication, anything at all. So those kinds of injuries or illnesses are going to be recordable. And they give you some examples here. Now, remember, this is work-related. So work-related cases of cancer or chronic irreversible diseases, silicosis, other types of things, punctured eardrums, fractured or cracked bones or tooth, these are going to be recordable. Now, there's some specialty cases of recordability. What we've gone through so far is maybe some general recording criteria. So there's a few that are kind of special. The first one is hearing loss. If the employee has experienced a standard threshold shift, and a standard threshold shift is defined in blue on this slide at the bottom, a change in hearing relative to baseline audiogram of average of 10 decibels at 2, 3, and 4 kilohertz, an average in one or both ears, and their overall hearing level is 25 decibels or more above audiometric 0, then you've got a case of work-related hearing loss. Now, still got to be work-related, so you've got to make the determination, did anything in the work environment, was it a discernible cause of their hearing loss? That person can go to, NASCAR races every weekend. They can go shooting. They can be in a rock band. They can do all sorts of stuff that exposes them to loud noise. But if they work in a work environment that is, for example, above 85 decibels over 8-hour time weighted average, it's going to be tough for you to say that at least the work environment didn't contribute. So again, remember, it's a discernible cause, not necessarily the only or major cause. But that's hearing loss. There's a diagram here about how to look at hearing loss, but it basically just follows the decision-making process that we just covered on the previous slide. There are other specific record-keeping issues. Some of them get into like bloodborne pathogens or maybe work-related exposure to tuberculosis or even ergonomics. But in the interest of time, we're going to move on. There is a form that the forms we've been talking about are primarily the 300 form, which is your main log of injuries and illnesses. The 300A is your summary form, and then the 301 form is your detailed record. So at the end of the year, and by the way, these forms are kept on a calendar year basis. So you start a new one January 1st and you finish it up December 31st. So at the end of the year, you finish up your 300 log and then you transfer the information to the summary, the 300A. You're required to certify that summary, and we'll talk about how you do that in a minute. And then you're required to post a summary. We'll talk about that. So who can certify the summary? It's got to be somebody on this list. Can't be just anybody. It's got to be an owner of the company, an officer of the corporation, the highest ranking person at the establishment, or their supervisor. So you got to get one of those people to certify that summary is correct. And then you have to post the 300A from February 1st to April 30th of the year following the year that summary covers. So next February 1st, you'll be posting information for 2021. You'll be posting the summary information for 2021. Where do you post it? Where you normally post things. By the time clock, where they walk in, the break room, wherever you normally post things. Now, to this point, we've been talking primarily about recording with a C, right? So recording with a C, we talked about the exceptions and who has to do it and how it's done and all that. Now, reporting with a P, that's different. Now we're talking about having to actually call OSHA up and tell them, unfortunately, we've had something bad happen. These are the more severe injuries and illnesses. So fatalities, hospitalizations, amputations, losses of an eye, those are all required to be reported to OSHA. As I mentioned, you are also required to provide records to either OSHA or Bureau of Labor Statistics or NIOSH and OSHA if they ask you to do so. Otherwise, you just keep these records and keep them on file. You're required to keep them for 5 years, and then you don't have to do anything with them other than post the 300A unless somebody comes in and asks for it like OSHA. So again, the reporting part of it, fatalities, you're required to report within 8 hours of the event. All the other three, you're required to report within 24 hours. You don't need to report highway, public street, motor vehicle accidents outside of a construction work zone. If it's inside a construction work zone, you need to report it. You don't need to report commercial airplane, train, subway, bus accidents. Now, keep in mind, those last two, those might be recordable, but they're not reportable. Okay. So you're driving in your car and you're on a work-related trip, and you're involved in a motor vehicle accident and you're seriously injured, well, it might not get reported to OSHA, but it might get put on your 300 log as a recordable case. How do you report? The best way to report, first and foremost, would be to call the area office where that has jurisdiction over that employee, where they're the establishment they're linked to. If it's off hours, then my recommendation to you would be to call the 1-800-321-OSHA phone number. That's a number that is staffed 24/7, 365. There's always a person there. So I would call that number. There actually is a place where you can go on the OSHA website and report. Personally, I would rather talk to a person. This is a significant event that has occurred. I'd rather make sure I tell somebody. But that's how you go ahead and report. Okay, so we've covered a lot. At this point, we're going to stop and see what kind of questions you guys have.
Thank you, Paul. And as a reminder, there's a couple of ways you can submit questions if you have any. One is to paste them into the Q&A box or chat, and the other is to raise your hand. There's a little icon that you can click to raise your hand, but either way will work for submitting questions. Okay, so it appears we don't have any questions at this time. Paul, I know you had to skip over it a little bit for the sake of time. Can you talk a little more about bloodborne pathogens?
Yeah, sure. Bloodborne, and again, I don't know all the different types of establishments that you guys work in. But for example, bloodborne pathogens, any needle stick or sharps injury involving a contaminated object is recordable. And so there is a standard, the bloodborne pathogen standard, that's 1910-1030, describes what is contaminated and what's not. So if the object, the needle or the sharp object is contaminated with someone else's blood or other potentially infectious materials, other bodily fluids that can transmit bloodborne diseases, then it is automatically recordable. Other exposures, such as getting a splash of blood into your eyes or something like that, is only recordable if it results in the person actually coming down with a bloodborne disease like hepatitis B or something like that. So that's bloodborne pathogens. I did also want to mention, and I think Kenny, I keep saying Kenny, Brandon put this in the chat, that there is a whole page of frequently asked questions on COVID-19. So if COVID-19 is on your, still on your radar in terms of those decisions, look at the frequently asked questions. For example, one question that is an interesting answer. If you require your employees to take the vaccine as a condition of their employment, the question is, are there adverse reactions recordable? And the answer is actually yes. If you require your employee to take the vaccine as a condition of their employment and they have an adverse reaction, it is work-related and it would be recordable if that adverse condition met one of the general recording criteria, such as medical treatment required, days away, days restricted, etc. Any questions?
Have kind of a quiet group today. It doesn't look like we have any questions at this time.
I must have done a really, really good job of covering record keeping. or maybe you want to wait and ask your questions individually. I don't know. But I do want to tell you, please feel free. You've got our contact information. So if you think of questions in the future, please feel free to contact any of us. You see myself and Brandon on the call from the Safety, Health, Environmental Group. But any of us would be glad to help you with record keeping or any other safety, health, environmental issues. And please keep in mind a consultation program. I hope some of you are eligible and interested in that program. We'd love to work with you.
It looks like we might have a question potentially from Kathy Gaines.
Kathy, do you have a question?
It does not appear so.
Are they muted?
A little bit of difficulty with my chat. Let's see.
If you want to throw your question in the chat too, feel free. I don't know if everybody's still muted or not.
No questions. So at this time, then I guess we can wrap up, unless anybody else has any other questions. But if not, first of all, thank you, Paul, and to the Georgia Tech Safety, Health, and Environmental Services team for joining us. Thank you to Carmen, Lita, Scott, and the Atlanta Airport Chamber of Commerce for co-hosting this. There will be a recording of this session made available if anybody is interested in that. And other than that, I don't have any additional comments or upcoming events at this time. Do you want to say a few closing remarks, Paul?
Sure. So again, just a reminder, we're here. We have a lot of programs like this one that are available to you at no cost. We have a wide variety of courses that you can pay to attend on a variety of safety, health, environmental topics. So if we can be of service to you, feel free to contact us. And thank you very much for attending today. I appreciate it.
Also, if I might add to that, this is Carmen Lita. You know, safety is the #1 priority for most companies. So, Paul, thank you ever so much for sharing this valuable information. I'm sure all of us can use it in some manner.
My pleasure. Thank you, Carmelita.